Hi everyone, thank you for joining us. I'd love to welcome you all here, and I'd like to start the webinar by doing an acknowledgement of country. So in the spirit of reconciliation, Avant acknowledges the traditional custodians of country throughout Australia and the connections to land, sea and community. We pay our respect to their elders past and present and extend that respect to all Aboriginal and Torres Strait Islander peoples today. So I'd like to introduce the estate planning essentials to you. So first of all, we've got the general disclaimer. Everything that we present tonight and that you hear tonight is of general nature. If you want specific information relating to your circumstances, please feel free to reach out to us after the webinar. So I'm going to give you an overview now. So the very first thing we're going to be going through is understanding asset ownership, because that's one of the most important aspects of your estate planning. And in doing that, we'll touch on superannuation, and we'll also touch on family trusts and how the control of those can be passed. And then, of course, we'll talk about wills, as most people understand that is one of the main tenets of estate planning. And that will include a conversation about testamentary trusts, which is a way of providing asset protection and taxation advantages to your beneficiaries. And then we'll talk about powers of attorney and how you can nominate who you want to be making decisions for you whilst you're alive, but particularly if you've lost capacity. So on that note, I'd like to hand over to Michael Mobley, who is a senior associate in our team, and he's also an accredited specialist in wills and estates. So Michael, handing over to you.
Thanks, Jen, and thanks everybody for your time this evening to talk about all things estate planning. Now, before we talk about making a will, it's really important to understand the different ways that we can hold assets. Ownership of assets is really important because it can dictate where an asset goes should you pass away, and it can lead to unintended consequences if you're not careful. So on this slide, there are a number of different ownership arrangements that you may or may not have come across before. Now, moving from left to right, we have solely owned assets, and this might be, for example, a car or a bank account that you hold in your personal name. We then have joint ownership, and commonly this covers things like real estate with a spouse or a partner. We then have superannuation. And finally, we have assets and interests as part of family trusts, which you might sometimes hear called discretionary trusts. So what does this all mean when we're looking to make a will? Well, the short answer is we can only give away things that we own in our sole name. So if we hold assets in a different way, we may have to take additional steps to make sure those assets end up where we intend. These assets are commonly called non-estate assets. And I want to start off with a very common example, which is owning property with another person. Now, there are two types of ways you can hold property with another person. And the first is what we call joint tenancy, and the second is tenants in common. So if we hold assets jointly with another person, that asset will pass automatically to the surviving owner should one of them pass away. And so I like to call this the last man standing approach, because it doesn't matter whether you hold property jointly with one person, 5 people, 10 people. If it's held jointly, it's when the last person has died that the asset can be dealt with, and only then in the last person's will. By contrast, though, if we own property as tenants in common, what we're saying is that each owner holds a specific percentage, and that could be 50-50, 60-40, or some other combination. And when that person dies, their percentage instead passes via their will. So depending on your circumstances, one style of ownership may be more beneficial than another. So for example, couples will often hold property jointly so that if one passes away, the house automatically goes to the other. This arrangement, though, might not suit friends who buy an investment property together and want their share to go to their respective families should anything happen to them. So you can imagine what might happen if I own property as tenants in common with someone, or at least I think I do, and it turns out to be joint tenants. All of a sudden, something I thought I could give away in my will has now gone somewhere else entirely. And depending on which state I live in, there may not be much my beneficiaries can do about it. Moving on to another asset now, which is superannuation. Now, most working Australians will have some amount held in super in a member balance account. But what you might not know is that you don't technically own your super. And this is because super is a type of trust arrangement, meaning that legally it's owned by someone else. And in this case, it's the super fund trustee. And it's held there for your benefit. So when we remember we can only give things away that we personally own, what then happens to our super? Thankfully, super legislation says we can do something about that, and that's what's called a death benefit nomination. And this tells the super fund where we want our balance to go should we pass away. There are some restrictions to this though, and the biggest one is that you can only pay it to certain individuals or dependents, such as a spouse or a minor child. It's very common to see people nominating others like parents or siblings, and unfortunately, those aren't necessarily going to be valid. With the right type of nomination though, you could also elect to pay the super to your estate and have it divided per your will that way. How much tax you may pay on that super will really depend on who ultimately receives the payout. So what happens though, if we make a nomination that's expired, or we nominate someone that isn't eligible, like that parent or sibling I mentioned earlier? At that point, the super fund trustee will have to decide which eligible person or persons will receive that death benefit, which can be very different to the person you intended. This, along with potentially significant tax outcomes, can mean you must take great care before you decide what should happen to your super. Moving on now to private companies. This can cause quite a few ownership issues. Take the example of a doctor who might have shares in a company, which in turn operates their medical practice from a commercial property that the company owns. The doctor may be one of a number of directors that runs that business day to day. In the doctor's will, we can give away that doctor's shares in the company, but the actual business and the commercial property is still owned by the company itself. So if the doctor passes away, they're no longer a director, and it's now up to the remaining shareholders to decide who should replace the now deceased doctor. This might cause significant headaches if the doctor's family thought they were inheriting ownership of the property, or even just the shareholders voting against the now deceased doctor's family moving forward. A business succession plan can really help avoid this, which we might talk about later. I now want to move to the last ownership asset structure, which is the family trust. So often people will set up family trusts as an investment vehicle for themselves and their families. And the trust may hold cash or shares. It could be a property like a farm or a holiday house. But in any given year, it's up to the trustee of the fund to decide who receives the benefit of any income earned by the trust. And the hiring and firing of the trustee of the trust is determined by a person we call an appointor. As the assets are owned by the trust, though, and not by a particular person, we can't actually give away those trust assets in our will. It is possible to pass on that role of appointor to another person via a will, but this ultimately depends on the terms of your particular trust. So having made our way through all these slides now, you're probably thinking, is there anything actually left to be dealt with under a will? And the short answer is yes. There are plenty of things that still fall in the definition of what we call estate assets, as you can see on this slide. The important thing to remember really is that preparation is key. Knowing the ownership structure of your assets and putting in place the proper documents, such as a will, death benefit nomination, or a succession agreement, really can save your family significant headaches or disappointment down the track. And on that note, I'll pass to Jen on how to make a will.
Yes, thanks a lot for that, Michael. It's one of the most important things that a lot of people don't fully comprehend is how things are owned. It makes such an impact on how you structure your estate planning. So moving on to making a will, I thought I'd start by saying, well, what happens if there is no will? So actually we published an article on this not so long ago, and I think the link to that article is going to appear in your chat momentarily, so that will give you a lot more detail about that. But in general terms, if you don't have a will, then what's called the intestacy laws apply. So that's sets of legislation. Every state has them, and they vary slightly, but generally run to the same sort of format. So if you die intestate, it means you die without a will. And some people think, well, if I don't have a will, everything's just going to go to my spouse. And sometimes they're happy about that and sometimes they might not be, but it's not always the case. And that's particularly in the case of second relationships. Some of the states prescribe that the spouse and the children from the first marriage have to share in the estate. So it's important to understand what really might apply to your circumstances if you don't have a will, or make sure that you do get a will in place. Usually if there's no spouse or descendants, then it sort of flows in accordance with what you would think of as your next of kin. So up to parents, if you've got no parents surviving, out to siblings. If they're not surviving, then down to their children, nephews and nieces, and then back up to aunts and uncles and so on. And some states stop at a certain point. So after that, if there's no family members alive, then it will pass to the government. And I don't know too many people that want their estate to just pass to the government without them having a say in that. So good sort of incentive to make sure that you have a will in place. So who can make a will? So generally, again, every state has legislation. Each state has their own Wills Act, but generally they are pretty similar in content. So people who are over the age of 18, or if they're under 18 but married, or they're under 18 and they get a court order. So for example, someone who's 16 or 17 and has assets, they might have some assets from working, and they might have a terminal illness and they want to state who is going to receive those assets. So they need to get a court order, and the court would usually in that circumstance allow them to do a will. So they must understand the nature and effect of what a will is. So that a will is something that disposes of their estate. So they really have to have an understanding of what the assets are. And that gets back to what Michael was saying. What is it that your will is going to cover? And that's the assets that you own personally. They've got to know who they wish to administer the estate. So who is going to be their executor? So the executor is the person who will have the authority to administer the will and give effect to the wishes in the will that you set out in your will, and make sure the beneficiaries receive what you want them to receive. Then someone making a will has to understand who they want to benefit. So they have to think about, well, who's in my family? Who do I want to benefit? Is there charities? Is there friends? And in what proportions and things like that. So not only who they perhaps should be considering, but who they actually wish to benefit as well. And I'd like to sort of flesh this out a bit further by going through a case study, a bit of a scenario we put together, which sort of shows what can happen if you either don't have a will at all, or what can happen if you just have a very simple will in place. So I'd like to introduce Graham. Graham's a doctor, a widower, and a father. So Graham has 5 children, and his estate's worth about $5 million, funnily enough. So they're all going to inherit about $1 million each. That's what he wants them to inherit anyway. So he's got Brian, who has no issues. He's employed in a stable job. He's in a stable relationship. He's got a couple of children, and everything's going fine there. And then he's got Carol. Carol, again, in herself, she's a sensible grown woman. She's also employed, but her husband's gone into business and needed someone to go guarantor to secure some loans that he wanted, that he needed to get his business off to a good start. So she's gone guarantee for him. So if his business, something happens to that, then the creditors will call upon her assets, particularly the bank that's provided the loan. Then we've got Michael, who unfortunately is going through a relationship breakdown. It's heading that way. So Graham's concerned that if Michael inherits his $1 million, that's just going to go west in a divorce settlement, which is the case if he just inherits personally in his own name. It will be not necessarily go to his ex-spouse, but it will certainly be in the pool of marital assets that are vulnerable to or subject to the discretion of the family court if it gets to court about how assets are going to be divided. Then we've got Paula. So Paula, unfortunately, she loves the horses, Paula. So she's always down the track and always throwing good money after bad, trying to get that big win happening. So there's some concerns there about what might happen to her inheritance. And then we've got William, who has an intellectual disability, and William will not be in a position to manage administering his finances, and certainly not a large inheritance of $1 million. So in the case where all of the, Graham dies and all of these children inherit in their personal name, which would be the case if he didn't have a will or he just had a standard will in place, who is actually going to benefit after Graham's death? So for Brian, he will inherit his $1 million, and nothing wrong with that, but he decides to invest it. And Brian, being on a fairly good income, and as is his wife, they're already sort of pushing the top income tax bracket. So when Brian inherits his $1 million, let's assume he's going to be generating $50,000, $60,000+ a year, then around about half of that is going to go to the tax office. So the tax office will be benefiting almost as much as Brian in that particular scenario. Then if we move on to Carol, so unfortunately Carol's husband's business goes bad and her guarantee is called upon. So because her inheritance just went into her personal name and she signed the guarantee, all her assets in her personal name are subject to that guarantee. So her husband's creditors are the ones that benefit there from the inheritance that Graham has left her. And then we move on to Michael. Yes, so the divorce does end up happening, and so his inheritance goes into the marital pool, and they end up in the family court, and the family court decides that it's fair and equitable for the ex-spouse, and there's the management of children and all those sorts of things, that they decide that some of that inheritance should go to the ex-spouse. Then we've got, Paula, who's a gambler. Well, yes, she does. Her eyes light up rather large when she gets that $1 million deposited into her bank account. So she's straight down the track. And so it's the bookmakers who pretty quickly benefit from her inheritance. And then young William, he unfortunately loses his pension, because with $1 million, he's going to well exceed the Centrelink asset test and income test threshold that applies, which for a single person without a house is approximately $370,000. So inheriting $1 million means he's going to lose his pension, and not only that, he's going to lose the healthcare card and PBS benefits and things like that. So could we have done better? Well, yes, we could. And the simple way of doing that is to have a will in place, but also provide testamentary trusts. And then move on to discussing how testamentary trusts can assist in a lot of these issues. So a testamentary trust can be set up in the will. And if we're talking about Brian and Carol and perhaps even Michael, we're happy for them to perhaps be in control of a testamentary trust. So we'd be looking at perhaps what we call a flexible testamentary trust. You can call it whatever you like, but that's the name we've given it. So the trustee is usually the beneficiary, and the appointor is also the beneficiary. So the beneficiary can appoint who they want to be trustee. So in Michael's situation, it might be the case that you put someone else in as trustee and you don't allow him to be the trustee, so that he doesn't have, he's more removed from his inheritance. So obviously you've got to put someone in who Michael trusts and Graham trusts, so that once his divorce settlement's over with and that's all done and dusted, then he can perhaps resume being the trustee. We can't say that testamentary trusts are absolutely bulletproof against relationship breakdown and claims in the family court, but it's certainly better than having Michael's inheritance just going into his personal name. Certainly for Carol, if her husband goes bankrupt and she had her inheritance put aside in a testamentary trust, only the assets in her personal name, if that's a guarantee she signed, are vulnerable to his bankruptcy and potentially her bankruptcy, and her inheritance can be kept aside in the testamentary trust and protected. And then for Brian, what a testamentary trust does is allow the income to be streamed. So all these people around the bottom of the slide, so Brian is the primary beneficiary, his spouse, his children, his grandchildren and other relatives, any charity in the world, and any companies or other trusts that he's created in his lifetime. He can decide every single year, as he's investing his inheritance and it's generating income, who is going to receive that income. And usually that's sometimes a tax question as well. So he would work with his accountant about who needs the income, and whoever gets the income pays the tax at their marginal rate. Now, one of the main benefits of the flexible testamentary trust is that minor children, so we've got the benefits over here, we've got asset protection, but in this second block here, distributions to children under 18, still taxed at adult rates, which means with some offsets, you can stream about $22,000 a year to Brian's children. And assuming they're young children with no other income of their own, they can use up their full adult tax-free threshold by receiving that inheritance, the income generated, and it'll be totally tax-free. Whereas if all the income had gone to Brian, especially if it inherited just in his personal name, it would be taxed at his marginal rate, which, if he's on the top rate, 49 cents in the dollar or whatever it is at the time. So very tax-effective vehicles. And Brian, who's the trustee, he can decide every year who is going to get the income, and he can chop and change every year depending on what the best tax outcome is and where he wants that income to go, because whoever is allocated the income, that income then belongs to them. So income distributed to children, it can be used for their private school fees, football boots, that kind of thing. For those in control of the trust, like Brian and Carol and perhaps Michael, they can wind up the trust if it's no longer suitable or dispense with it from the beginning. With someone like Paula, the gambler, you would put perhaps someone else in control. And then with William, you could set up what's called a special disability trust. And a special disability trust has further exemptions from Centrelink means testing. So usually the first $750,000 is exempt from Centrelink testing, and the remainder wouldn't be enough for him to lose his pension. So that's a good outcome for William as well. So we can draft testamentary trusts so that they can be as protective or as flexible as you want to suit each particular beneficiary. So now I'd like to take a break, try and get my throat back in order, and I'd like to throw over to Rachel, who is going to take you through powers of attorney.
Thanks, Jen. Hi, everybody. So my job tonight is to talk to you about powers of attorney, which are documents that will come into effect if you are alive but unable to make a particular decision for yourself. And those decisions are with respect to finances, personal decisions, and medical decisions. For a financial decision, you as the donor are able to appoint an attorney or attorneys, and you are able to appoint an alternative or alternatives. Some of the financial decisions that an attorney might make can be in relation to purchasing or selling an asset, such as a house on the market, paying your Telstra phone bill, and managing various investments like a rental property that you're deriving an income from. Some financial powers of attorney, there may be the ability for an attorney to withdraw a donor's superannuation member balance prior to their death, if there is the opportunity to do so, resulting in what can sometimes be quite a big tax saving. So that's always a good thing. And in some instances, a financial attorney can end up being in control of companies, family trusts, and self-managed superannuation funds, and that is dependent on the governing documents establishing those vehicles or entities. Requirements do vary from slightly from state to state. They are state-based documents. So the next decision that we'll move on to is personal and health, bearing in mind in Victoria we have a completely separate medical power of attorney. But for personal decisions, the donor can appoint an attorney or multiples. They can appoint an alternative or multiples. And sometimes this can be referred to as an enduring guardian. And some of the decisions that a personal attorney might have to make can be in relation to permanent accommodation or a carer in the home, any employment, and potentially restrictions on visitors. For a health or medical decision, the attorney can decide what medical treatment the donor receives or is refused. And when it comes to the medical treatment decision maker in Victoria, you can only have one nominated decision maker at a time in a specific order outlined on the document. You can also, in most jurisdictions, complete what's called a care directive, which will outline your directions and wishes with respect to treatment that you do or you don't receive. And the healthcare workers and the nominated attorneys will need to follow that. If a directive is not in place, then it is entirely up to that person who is nominated for that particular decision to make those sorts of decisions on your behalf. So some important things to note when it comes to your powers of attorney. The requirements do vary from state to state. Attorneys will cease to have the power to make those decisions on your behalf upon your death, or if the power of attorney is revoked by a new one or a complete revocation without a new one even being prepared, or if the power of attorney was enforceable during a specific time frame. So if you were to go overseas, you can have a financial power of attorney that's in place for the duration of your overseas journey. So your attorneys can attend to things for you whilst the donor is away, or you can have a financial power of attorney put in place for a specific purpose. So it might be for that investment property that you've got in a different jurisdiction. You can just make it purely for that specific purpose. You can, for some decisions, determine when the power is able to commence, whether that be immediately when the document is signed, when you've lost capacity, or you have provided written instruction. When appointing multiples, you will have the choice, whether that's jointly, which means that those nominated attorneys have to act together, jointly and severally, which means one or the other or all of them all together. It doesn't really matter who you appoint, who acts, as long as it's somebody that you've appointed, obviously. Or you could potentially have the ability to nominate someone by attorneys by majority. So if you were to nominate 3 people, at least 2 out of the 3 need to agree. Thank you very much for your time tonight. I'll hand it back over to Jen to talk about reviewing your estate planning and to take some questions.
Thanks, Rachel. So hopefully my throat's going to survive the rest of the evening. So obviously when circumstances change, it's, you've got to think about, does it make an impact on your will or your powers of attorney? So generally, we recommend that people have a look at their wills and powers of attorney about every 3 to 5 years. But obviously if something specific comes up, then that's going to trigger your thoughts, saying, oh, I better go and get that looked at, or at least pick up the phone and ask the question if something's going to impact. So some of the typical ones we've set out there, wills commonly contemplate children or further children, so just having another child born is usually going to already be covered in your will. But if your children become old enough to take on the executor roles or attorney roles, that's often a time when people update their wills. As their other executors get older and lose capacity or die, then obviously they need to think about replacing those roles. Another time that people often come to us to update their wills is if they've loaned money to a child, perhaps to help them put down a deposit for a house or something like that. They might have loaned them a couple of $100,000, and they want to make sure that that's equalised in the will between the other children, so that if they die and the loan hasn't been paid back, and they might not really be too concerned about it being paid back or not, but they want to make sure that the other children don't miss out. So they get their wills updated so that we can put an equalisation clause in the will, so that the child who's had the loan can then receive it as part of their, like an early inheritance. So that's often a trigger for updating your will. If you set up other entities like a self-managed super fund or a family trust, as Michael was saying before, there's particular ways in which those entities are controlled that can be separate to your will. So that's also a good time to review your estate planning to see how that's going to be managed. So that's kind of coming to the formal end of the presentation, but fortunately, we've had loads of questions come in. In fact, we had questions in the hundreds come in before the webinar commenced tonight, and we've had quite a few questions coming in now in the chat, I can see. So we've got plenty of time to go through as many of those questions as we can, and feel free to keep them coming. thank you for your attendance here tonight. It's been fabulous to see the amount of interest come in there. Another thing that we should put a link in the chat to is that we've just, if you're ever nominated to be an executor of an estate, then there's some things that you should consider about how to manage that estate. So there's a good article that Michael's just written a little while ago that's been published, and we're going to put a link to that in the chat. So on behalf of Avant Law, I'd love to like to thank you for joining us, and we hope you found tonight's webinar of interest and value. We'll be emailing a link to the presentation slides, so you've got them to jog your memory. They're probably not much good for someone who hasn't seen the webinar tonight, but for those of you who are able to join us here tonight, it could help you jog your memory as to what was discussed. For those of you who perhaps don't stay till the very, very end, as you exit the webinar, a survey will appear. We'd really appreciate you completing that survey. It really helps us understand whether the content resonated with you and whether it was useful, and it can help us inform future topics. And of course, at any time, if you've got any questions, you can feel free to email me, jennifer.jackson@avantlaw.com.au, or my colleagues, Rachel or Michael, or even just info@avantlaw.com.au.